Welcome back to session. Imina 37 na Legislature Guahan is back from recess. Thank you, colleagues, for being here to make a quorum for us. We have 8 members present. We will proceed. We left off on Bill number 332. Is there any other person who would like to speak on Bill 332? If not, then the sponsor may close on Bill 332.
Thank you, Madam Speaker. I'd like to thank my colleagues for the discussion on Bill 332, an act to expand the virtual power plants. Continuation of the work started by the 36th Guam Legislature and continued by the 37th. And as we go more and more towards a more solar future, hopefully that after my time in this legislature is done, others will carry the baton forward towards a more renewable future. So thank you all for your input and for your amendments. I'm just doing my part to move us one step closer to that renewable future, but I couldn't have done it without your support and your help. So thank you very much. With that, Madam Speaker, I'd like to make a motion to move Bill 332 to the third reading.
There's a motion to place Bill 332 as amended on the floor to the third reading. Is there any objection to that motion? Seeing no objection, that motion carries.
Thank you, Madam Speaker. I yield the rest of my time.
Just Masi, Senator. We're now on Bill 337-37 COR. Senator Barnett, you're recognized.
Madam Speaker, at the request of the author, at this time I'd like to motion to set aside Bill 337.
On the motion to set that bill aside, is there any objection? Seeing no objection, that motion carries. So now we are on Bill number 351-37 COR, sponsored by Senator Frank Blas Jr. and Joanne M. Brown. Senator Blas, you are recognized.
Thank you. Thank you, Madam Speaker. Madam Speaker, I move to place Bill number 351-37 COR as amended by the Committee on Health, Land, Justice, and Culture, introduced by myself and Senator Joanne Brown, which is an act to amend Section 7.10 of 9 Guam Code Annotated, Chapter 7, relative to exemptions from criminal liability due to juvenile status, and to amend Section 5106 of 19 Guam Code Annotated, Chapter 5, relative to the jurisdiction of the Superior Court of Guam, into the third reading, and I'd like to be able to discuss it.
Please proceed.
Thank you, Madam Speaker. And first off, Madam Speaker, note that the bill that's presented for the body for consideration is amended by the Committee on Health, Land, Justice, and Culture, and I want to thank the chairwoman for being able to do this. You know, Madam Speaker, this bill was brought about by some unfortunate incidences that have occurred in our community, whereby individuals were victimized, sexually assaulted by individuals who were currently of juvenile status. And when the assaults took place, obviously the victims were also younger. And when the incidents were finally reported, unfortunately, the perpetrator or the individual responsible for the assault was no longer a juvenile, but was an adult status. And there exists a, for lack of a better term, a loophole in the law. In what it did is it prevented the prosecution or the ability to prosecute the individual, because at the time they committed this heinous sexual assault, they were juvenile, but now they're an adult. And there's a glitch in the law that basically says that you could not charge the adult for something they did as a juvenile although the statute provides that that kind of assault or that kind of offense had no statute of limitation. So what this bill provides is the ability for the courts in its discretion to be able to, in the cases of an individual who commits a homicide or a criminal sexual assault, and is in that age between 14 and 16 years of age, and they were then not found, or the crime was not reported until they were adults, that despite that, this law provides the court the discretion, the ability to be able to prosecute that individual for that crime that was committed at that minor age. And in the earlier version of this bill, it provided so that regardless of the age, if the individual committed the crime, committed the offense, they could be tried as an adult. However, after discussions and after the public hearing and discussions more with the committee, it was then provided that in order to be able to, first off, not stray away from the intent of the bill. This is not a bill that would basically provide carte blanche in being able to go after 14 and 16-year-olds. This is a bill that would basically say that if you committed a crime when you're 14 years of age, just because you're an adult and you get caught as an adult, you're not scot-free on this, but just for homicides and criminal sexual assaults. And this bill provides the proper amendments to the sections of the law that pertain to the status of the offender. One of the things I have to note is that it still provides the court the discretion to be able to decide as to whether or not it should take it one way or another. It does not, it provides them the ability to be able to proceed with the judicial, basically going through the judicial process with the individual, but it does not say that they have to. It gives them that discretion to do this, and I think it's within their jurisdiction, it's within their area, and we wanted to be able to make sure that that is pretty much clear in this. So with that, Madam Chair, Madam Speaker, that's my presentation for this thing, and I look forward to any discussion and deliberation on the bill. Thank you very much.
Mrs. Masi, Senator. On the bill, is there anyone else who'd like to be recognized on the bill? Senator Brown, you're recognized. I'm just sorry. I'm concerned that we've lost our quorum. Okay, all right, please proceed.
Thank you very much, Madam Speaker. I also rise in support of this bill and certainly appreciate the initiatives as well of our minority leader, Senator Blas, to put this bill forth and allowing me the opportunity to co-sponsor this bill with him. You know, it's very concerning in our community and certainly not anything that we want to think about, but the reality has been there, unfortunately, Madam Speaker, where we've had children that unfortunately have been harmed by others. Sometimes they might be just a few years older, and some people may think, oh, you know, children will be children. But some of the harm that has resulted from this impacts the lives, literally the lives of these individuals for the rest of their life. And we have to deal with the sad reality in some cases that there are children in our community, unfortunately, that go on and continue to go on to become offenders of others. And we certainly have to have a means of addressing that, because we end up with these victims and the families of these victims that don't have any recourse because of this gap that exists in the law that allows these actions to happen, and then say, well, you know, if you made it past this certain finish line here, then you're no longer responsible or accountable, nor can you be charged for these crimes. And then we ask ourselves, where does this leave the victims that have been abused, that have been harmed, that carry this abuse with them the rest of their life? And then more so, the feeling that there is no justice for these children. that the individuals that perpetrated this harm upon them, particularly these cases of sexual abuse, there's no recourse. The court cannot or will not, under existing statute, entertain these type of cases. And I don't think that's the message that we want to send out to anyone in our community, because we have had victims that have been harmed, irreparably harmed, by these type of sexual offenses that have been brought upon them by, unfortunately, those that maybe just what we say, we may call them children, teenagers at a certain age. Some people, oh, you know, they're just learning about themselves or learning about their sexuality. They're just experimenting. But some of these cases are really harmful, very harmful, permanently harmful. And it's very frustrating for parents as well, who know that their beloved child has been sexually harmed. And then when they go to the police, they want to file a complaint. They want to make sure that the individual that brought this harm to their child will be arrested and taken to the judicial system, and that there will be justice, which is very hard in and of itself, because many choose sometimes not to, because they don't want to put their children through a trial. Because that in and of itself is like they're reliving the victimization that has been forced upon them. But we need to address this, because at the end of the day, as I always, there has to be justice. If there is no consequence, then somebody's always going to look to take advantage of that loophole. And you would think that we would not want to see that happen. But you know what? If there's a will, there's a way, even if it's the wrong way. Someone will find a way. And overall, no matter who perpetrates these harm upon our children, it should never be acceptable. It's not our community, it's not our value system, it's not how we were raised, and yet every day, almost every day, in the news, whether it be the TV news, you read the paper, you listen to the radio news, whatever the case may be, there's always a situation out there where our children are being sexually harmed and sexually abused. Sometimes maybe we think by a stranger, in some cases, other times within their own home, in a place where they should feel safe, harmed by those that are supposed to be positive authority figures in their life, that's supposed to protect them, that's supposed to help them, that's supposed to care for them. But that is not the reality, unfortunately, in our beautiful community on this bright, sunny day. Children continue from infancy, which we're dumbfounded by, because you go, how sick can people be? How sick can anybody be to harm an innocent child, an infant even? But we've seen it. It's happened in our community. Those that are most vulnerable continue to get harmed, and somehow it never ends. You know, this is an illness, they say, really, that cannot be treated. That someone that wants to sexually abuse children is a condition that cannot be treated. That's frightening. You know, as a parent, you're saying, God, not only throw that key, lock it away, and that's a person you never want to see out on the streets of Guam ever again. How does someone do something to those that are so vulnerable that cannot in any way, shape, or form protect themselves or defend themselves? How dare they be allowed to walk the streets of this island, in this community? But they exist. And as far as I'm concerned, there needs to be consequences. And those that have been harmed, there needs to be recourse. You know, we talk about justice, but we also find out when you've been around a while, there's not always justice. Sometimes it depends on who you are, what you are, and how much money you have. That's a sad reality. But that's not the reality any of our children should be faced with if they've been sexually harmed or harmed in any other serious way. And we've seen it. We've seen the murders that have happened in this community, sometimes at the hands of family members or boyfriends of family members. Really heinous things that have happened to our children. And if we're here to set policy for this community, if we're here to say that we represent what the standards of our society is on Guam, it should be at least absolutely not only no way, hell no way. And anyone who harms our children, regardless in this case if we're actually looking at the age, they should be held responsible. There should absolutely be no get out of free jail card. Right now under our existing statute, that exist. And we have had children in our community, young children in our community, that have been sexually abused, violated, harmed for their life, because this is a scar and a burden they carry. And only to find out that the perpetrator cannot be charged. Because you know what? They just skipped the line in their age, and they got away with it. And people that have this type of orientation, so we see, we read, we hear, it's not something that can be fixed. And if they do it to one child, where's the next victim? Who's going to be the next victim? And the next one after that, and the next one after that. So I say for here in our community, we should say this is not acceptable. We should strengthen the law. We should tighten this process to protect these children in our community, because we're finding out that there have been children that have been victimized and they have no recourse, their family has no recourse, and they receive no justice and a means of healing so that they can move on and know and understand that they are not the problem. They are not the reason that they were victimized. We don't talk about these issues enough because they're not comfortable issues to talk about. But it happens every day. Who doesn't know this situation or happened in their own families or friends or people they know? And I think we just need to stop this nonsense. And if they do dare to cross that line, by all means, there should be consequence. There has to be, because if there isn't, these individuals will continue to do what they do. And that's just not okay. So with that, Madam Speaker, I certainly rise in support of this legislation. Again, appreciate the efforts of my good colleague, Senator Blas, for championing this issue, and appreciate the opportunity to support this legislation with him. Thank you very much, Madam Speaker, for the opportunity to comment.
Senator Brown, on the bill, is there anyone else who'd like to speak on the bill? Senator Lujan, you're recognized on the bill.
Thank you very much, and good afternoon, Madam Speaker and colleagues. Madam Speaker, I stand in full support of Bill 351-37, authored by a good minority leader, our caucus leader, Frank Blas Jr. You know, I sat in that public hearing regarding this bill. And as was eloquently stated by previous speakers, Senator Brown and Senator Blas, regarding victims, young victims who were victims of child abuse or sexual molestation by kids who are a little older than them as well. You know, this bill was championed, or the genesis of this bill was championed by a family whose child was molested at a very early age by a underage child as well, who was quite a bit older than that young child. However, as was again stated earlier by the author, that the court had no jurisdiction when the case finally came up, because the underage perpetrator is now an adult, and the court had no jurisdiction. Family court had no jurisdiction over the adult. I'm not going to rehash what was previously said. The most disturbing thing about this whole situation here, as was presented to us by, and I'm sure numerous senators were visited by this family as well, is that in this particular instance, the champion of this bill, basically, the family that championed this bill, the perpetrator will shortly be in a position, maybe in a position right now, because that individual will soon be employed where they would have access to very young children. Very young children. That being said, the unfortunate thing with that profession, that this individual will be probably soon employed, has access now because of that particular profession that they're in at this point. And as the family has said, it may be too late for us, but we don't want other victims. And we know, as Senator Brown had previously said, this has happened. This is not just one instance of different families who have gone through the judicial system. And again, that particular court, the juvenile court, has no jurisdiction because that person has now grown into adulthood. This bill goes a long ways to close up that loophole, Madam Speaker. And again, as we read on a daily basis, if it's not drug-related, it's child molestation. If it's not child molestation, that's making the headlines as drug-related, and or both. We need to take this island back. And this bill goes a long ways, again, in closing up that gap and giving the courts, again, the tools, the mechanism to be able, again, to help deter. Now, would it cure? I don't think it would. As was previously mentioned, you know, this thing is passed on, and as in previous hearings, in other related bills, experts have said it's hard to treat. It's hard to treat. Perpetrators. Because perpetrators are usually previous victims as well. And so, again, I urge my colleagues to, again, support 351-37. It'll go a long ways to be able to help curtail the situations that families had to endure, and hopefully future families will not have to endure as well, or that individuals will have second thoughts and say, hey, no, I'm not going to get away with this. I know I'm a minor now, but it doesn't matter. I'm not going to get away with it when I become an adult. It's going to follow me. And so with that, Madam Speaker, again, I rise in full support of Bill 351-37, and I ask the good author if I can be a co-sponsor of the measure as well. Thank you very much, Madam Speaker.
Sujus Masi, Senator, is there anyone else who'd like to be recognized on the bill?
On the main motion, is there anyone who wishes to speak on the main motion? Speaker Terlahi, you're recognized.
Sujus Masi. I just wanted to talk on this bill as the committee chair who had the hearing on it and with the assistance of my colleague, Senator Brown, and also because of the really very hard decision for me it is to support this bill. The bottom line was that prosecutors are telling us we have rapists walking the streets because we are unable to prosecute them. And given the nature of that type of crime, it's likely that those people who have committed criminally sexual conduct in that degree in the past will continue to offend. That's the problem before us. And of course, on the other side, we have huge amounts of juvenile justice reform measures all across the nation, which are asking us to look at juveniles who commit crimes in a whole other way. There's something, their brains are not fully developed, and if they are committing crimes like this, there is something so wrong in their development or in how they were raised, how they were treated, so many things that our community must address. So I just don't want anyone to think this is a quick fix. It's such not a quick fix. It's going to give us something that we can do in the face of rapists walking the streets, perhaps. But it's not fixing that underlying issue of we've got 14-year-olds or 13-year-olds committing rape or homicide. That is really a huge challenge for all of us on Guam, everywhere. But it's multifaceted issue. So the bill was narrowed down in the committee to apply only in cases of homicide or criminal sexual conduct of the first and second degree. And that is what has convinced me to support the bill, is because of the narrowing of the bill to those most egregious of offenses according to our laws. And because first and second degree criminal sexual conduct, we want to do something about that. If we do not, they will repeat offend. That is what the statistics show us. And there is no science to make them do otherwise. First degree criminal sexual conduct involves victims under 14 years of age. That means they were assaulted or raped under the age of 14, the victims. It means somebody committed a crime on victims who were between 14 and 16 and related to the victim by blood or affinity to the fourth degree, or is in a position of authority over those victims. Or they committed this criminal sexual conduct under circumstances involving the commission of any other felony. Or they knew that the victim was mentally impaired, incapacitated, or physically helpless. They used force or coercion to accomplish the sexual penetration. They were armed with a weapon to lead the victim to believe, or something that the victim believed was a weapon. They caused personal injury to the victim and forced or coerced to accomplish sexual penetration. I don't even want to keep reading the list. It's so unbelievable that this actually occurs, that it occurs on Guam, but these are actually the facts of what we are facing. These are the facts of what we are facing on Guam. And the more we talk about it, hopefully we can get the victims to come out and report these things sooner, The more we prosecute these successfully, the more we can get the victims to trust our system. And that's what this bill is trying to do, is trying to get prosecution for the perpetrators so that the victims and more victims, perhaps of the same person, can come out and report what has happened to them. That's the goal of our system, is to get these very difficult to report situations reported. And that's the only way we're going to be able to stop them. And that is still very, very difficult. So we have to give these prosecutors, and I want to commend Christine Tenorio, who sent in testimony on this bill. She is the chief criminal sexual conduct prosecutor for Guam. She has done this for years, along with other prosecutors, but this has got to be the hardest prosecution work. The most difficult to get through, the most difficult to stomach. I've talked to these types of prosecutors who served in the past, and their stories are very similar. The people of Guam don't even necessarily believe or know what we are facing in this type of conduct, how often it occurs, whether people are able to be prosecuted or not, and how difficult it really is to prosecute them. So the bottom line for me is we're facing a multitude of issues, including how do 14-year-olds get to that type of a state where they can commit this type of crime? We need to address that, but in the interim, I do not want anyone who commits this type of a crime to go free, because our law has a loophole that allows them not to be prosecuted if their young victims aren't able to report them until a few years later. This is very common in criminal sexual conduct cases. The victims are so deathly afraid of repeat offense, of the threats that they will be killed. They are afraid that they will be shamed by our entire community, and we must allow them any protection that we can. And that's the reason I support this bill. It's very unsatisfying anyway to say this is the only remedy that we have, but it's hopefully one of the tools that prosecutors can use when they know, and it is reported to them, that someone, perhaps 18 now, was committing rape at the age of 14, and right now roams free because they're unable to prosecute that person because of that loophole. So again, I support the bill, and I want to commend those prosecutors doing this type of work and encourage them to continue. I know it's very difficult, and I don't think our community appreciates all of the behind-the-scenes work that it takes to really get victims to trust in our system. That, I think, is one of our most difficult challenges, and that their names will be put in the paper, their situation, their testimony, their families, their emotions, all of it. But I want to give these prosecutors the tools that they need so we have none of these loopholes continue. So,
Madam Speaker, on the main motion, is there any senator who wishes to speak on the main motion? Senator San Nicolas, you're recognized.
Thank you, Mr. Speaker. Now, it's nearly a month ago. I was already giving my goodbyes to Senator or the Speaker-elect, and he says, "Hold on, we're not done yet." And I I thought back to that, and here we are now. He says, don't worry, we still have a couple more weeks left. And as we draw down this term, it gives me great honor to stand in support of this this measure, this bill. And I really thank the author for addressing this issue. I always hearken back to my other experiences. I actually could say that I stared into the eyes of evil at such a very young age as a school counselor. I had to deal with criminal sexual conduct. I don't know where kids go wrong sometimes. Bad parenting. I heard a story many years ago. I think it was from a priest, and he says there were two kids who were being raised, and one of them became successful, and one of them wasn't successful and ended up behind bars. And these kids were raised by a very terrible father. And when they asked these two children, these two adults, when they became adults, they both answered the same way. The one who was successful answered, with a father like that, how else was I supposed to turn out? They asked the guy that was in jail, the twin. He said the same thing. With a father like that, how was I supposed to turn out? When I stand here and I give my testimony or my message on the measure, I kind of like to think about Hammurabi or King Solomon, you know, trying to weigh it out. And for a long time, we've let minors who committed crimes slide after the age of 18. And it just boggled my mind, you know, how can our system allow this to go on for so long? But, you know, like I said, I recognize evil doings and beings at such a young age. They can do this. And it really is up to choice. Like, how old are you before your choice is your choice? And how old must you be before you be punished for that choice? And here we're making that very, very clear, that you can be at any age and perpetrate a heinous crime like this, and the law will fall on good. The law will always seek good. The law will always seek justice. It's as a school counselor, I had to deal with criminal sexual conduct cases, and I'll tell you, they, like Senator Joanne Brown, they carry these scars for years, and sometimes they never grow out of it. They just carry this pain. And having this type of measure and the justice that it seeks can bring some type of closure, no matter how small. And I'd like to thank you, Mr. Speaker, for giving me the opportunity to do so. Sorry I got in here at such a I was kind of late, so beg your pardon for my tardiness. But I really wanted to speak on the measure and thank the good author for introducing the measure. And if it's not a problem, I would like to also be a sponsor. Thank you, Mr. Speaker.
Senator Spasi, Senator Nicholas. On the main motion, is there anyone who wishes to speak on the main motion? Senator Parkinson, you're recognized.
Thank you, Mr. Chair. When a letter from the victim's mother to the senators was sent out, I read it, and I reread it. And I read it again because I could not believe what I was reading. This woman was living the nightmare of every parent. And as a new parent myself, it filled me with a rage to think about how somebody could hurt a little child. I've always been one for restorative justice, but when people hurt children, we should absolutely throw the book at them and use every tool at our disposal to keep our children safe. I'd like to share with you an excerpt from the letter from the parent. I won't share all of it because some of it is very graphic, but it's a part at the end that really stuck with me. He didn't feel guilty the first time, the second time, and not even the third time. No remorse has been shown for my son, not from the perpetrator and not from this law that's put into place. The invitation this case gives to other predators who are minors to prey on young kids as little as they can remember because they think no one will believe a child so young, and when the child finally recalls the incident, it'll be too late. Just like this case with the perpetrator confessing to brutally sexually assaulting my child and getting away with it, if future predators catch the perfect window to commit the same crime, who's to say that they won't? I found out through family that the perpetrator is an education major at UOG and is studying to be an elementary school teacher. I worry for the future safety of his future students, knowing that he sexually assaulted my son and got away with it. He has been empowered by our justice system to do it again. Normally, when someone is charged and confesses to sexual assault, they must be registered as a sex offender. But due to the lack of action by our court, the perpetrator will never have to be identified as a sex offender, allowing him to be in contact with more potential victims. Please protect our children. Please protect our children. That's what this mother's plea was. And it is a plea that I intend to answer. And I stand in full support of this bill. And any bill that will put another layer of protection between our children and these monsters. There are monsters out there, and we must protect ourselves and our family and our community from them with our laws and with our actions. And I hope the actions of this body are unanimous today, that we will not look the other way, that we will give this our full attention, and that we will plug the gaps in our laws so that this does not happen again, that this miscarriage of justice does not happen again. As a parent, this is a worst nightmare, and my heart goes out to that woman and her family. But it is now incumbent on us to do right and fix this mistake. So I stand in full support, and I also to request to be added as a sponsor to this measure. Please protect the children. Let's answer that call. With that, I yield the rest of my time, Mr. Chair.
Senator Swansea, Senator Parkinson. On the main motion, is there anyone else who wishes to speak on the main motion? Is there anyone else who wishes to speak on the main motion? If not, Senator Blas, you may close.
Thank you, Mr. Chair. And I want to thank my colleagues for their contribution and their presentation and support of the bill and the work that was done on the bill. You know, Mr. Chair, my co-sponsor to the bill is humble. And I will be remiss if I didn't speak of her insistence, her persistence, almost making sure that we get this bill done. Senator Joanne Brown. She is just as much the main sponsor. She is the main sponsor as I am. I don't want that to go unnoticed, because I'm sure immediately as we got the notification, the letters, I don't know whether she has me on speed dial or not, but she called pretty quick. And I felt the need to be able to work towards drafting the bill. As was mentioned by the speaker, I want to thank the Office of the Attorney General, more specifically the Assistant Attorney General and lead prosecutor for criminal sexual conduct, Ms. Christine Tenorio, my daughter, for also being insistent and for helping and being able to draft the legislation and to making sure that it goes through. To the committee for their arduous work on this, because I know there was struggles with regard to the language as was originally proposed and the language that exists now, so that we can ensure that this is something that will work. Most especially to the families. The two in particular, and for purposes of wanting privacy, and it cannot be mentioned, but I'm sure they know who we're talking about, what I'm talking about. Thanking them and the victim for, while justice may not have prevailed for them, justice will prevail because of them. It took a lot, it always takes a lot, for a victim very much just to come forth, recognizing the scrutiny, the anguish, the embarrassment that may come. What was done to them was not right. What this bill provides now is that if it's going to be done again, it will be taken care of. And this is the kind of bill that can fill you with emotion and passion and the need for it to happen. I'm just glad that we've got it to where it's at right now. I can hope that not only does it pass unanimously in this House, but it is signed almost immediately by the governor, so that we can continue to protect our children. Mind you, that this bill, already if a 14-year-old commits that heinous act and is caught as a 14-year-old, he can be tried. What this bill provides is that if the individual commits this crime as a 14-year-old and think that because he's a 20-year-old now, the court has no longer any jurisdiction on him, and so therefore he can get scot-free. Not anymore. There is no statute of limitations on first-degree criminal sexual conduct or homicide, and you will not get away with it. That's the clear message that we're sending. Do not harm our children. Therefore, Mr. Speaker, before I end, I want to make a motion to add co-sponsors to the bill. I move to add Senators Talatayagui, Jesse Lujan, Will Parkinson, Dwayne St. Nicholas, Chris Duenas, Therese Talai, and you, sir, Senator Chris Barnett, as sponsors, main sponsors, sponsors that want to be as part of this bill. I move for that motion.
Sujo Senator, on the motion, is there any objection? Seeing, hearing none, motion carries. Senator?
Thank you, Mr. Chair. And with that, Mr. Chair, I move again to place Bill 351-37 COR as amended on the floor and amended in committee into the third reading file.
On the motion, is there any objection? Hearing none, motion carries.
Thank you.
Sujo Senator. Colleagues, we're now on Bill number 356-37 COR. Speaker Terlahi, you are recognized. Bill number 356-37.
I'd like to move Bill number 356-37 COR as amended by the Committee on Health, Land, Justice, and Culture, sponsored by myself, Therese M. Terlahi. It's an act to amend Section 10407 of the Guam Board of Allied Health Examiners Administrative Rules and Regulations relative to including licensed professional counselors as clinical supervisors and mandating licensed clinical psychologists or psychiatrists licensed in Guam to hold a license for a minimum of 3 years. This is, we're amending one rule by this bill, and we are doing that to make that rule that they are using for licenses to be consistent with the law that we have put in place. It's pretty much as simple as that. The rule is a little inconsistent. We wanted to make it consistent in the speediest way possible so that it's that fluke in the law, in the rule is not used to prevent the licensing of licensed professional counselors. Guam is in huge need of licensed professional counselors, psychologists, psychiatrists. We are in a mental health crisis because of the lack of professionals. So we can use all of the professionals that we can get, who of course are competent and can pass all the other criteria. So what this bill does, it was a concern brought to us by some on the HPLO, the Health Professional Licensing Office, because they had been debating in their meetings what looks like an exclusion of who can supervise. So right now, by law, to become licensed on Guam, you have to have met a certain number of hours of clinical supervision by. To become a licensed professional counselor, you must have been supervised by a licensed professional counselor, a licensed mental health counselor, or marriage and family therapist in Guam, or by a clinical psychologist or psychiatrist licensed in Guam, or a licensed clinical social worker. That's what the statute says. And then there are rules that talk about if you are a supervisor, what you have to do. And then one rule talks about if you're going to supervise by telehealth. And in that rule, they had removed licensed professional counselor as one of the people who can be your supervisor. So as you'll see on bill on page 2, we are adding back in the words licensed professional counselor. We've put the clinical psychologist or psychiatrist licensed in Guam, who has held a license for a minimum of 3 years, to also be consistent with the statute. And I'd like to propose a couple floor amendments. Were these, does the clerk have these? Oh. I apologize. The floor amendments, I guess, have not been copied yet.
All right, we're going to take a short recess to allow the clerks the opportunity to pass out the amendments.
Sí, sus pies.
Colleagues, we're back from a short recess. There were a number of amendments passed out by the clerks. Speaker Terlahi, you have the floor.
Thank you. I'm just troubled because I'm trying to pass amendments. We're going to need 8 votes on any amendment, and there are not even 8 people here. Apparently, we've lost our quorum again. Some senators came and left. I'm just not understanding it. We've got several people off island, but we should be able to have a quorum even with those off island. But there are just some senators without any reason that I've been given, just not present today. I would ask our Sergeant of Arms to call these senators, see if they're going to be coming to session, because I don't want to waste our time, my colleagues' time. We've got business to finish. Maybe they think because it's not even, you know, we've gone through an election that we shouldn't be doing any work. I totally disagree with that. We all planned for a month of December session. We've put that notice out since the beginning 2 years ago. So I don't know. I would like to move these bills that really people are relying on. It impacts their lives. Let's do our work. Otherwise, end the terms after the election, but that's not what the Organic Act says. I just think it's arrogant. So, do we have 8 now?
Madam Speaker, it looks
Thank
like we have 8 present. You have the floor. You may proceed.
And thank you, colleagues, for being here. This is, again, it's to facilitate the licensing of licensed professional counselors. And when we first started the bill, the provision that we were sent by the HPLO and the provision that we are amending today, we thought would really solve all their problems, but we come to find out that they really had in the statute the authority that they need, but the rules are inconsistent. So we're going to make these rules consistent so that there is absolutely no question, no interpretation, or no impediment to licensing these professionals if they meet all the other qualifications. So please bear with me. There are several amendments. The first one is just to the intent of the bill. On page 1, I'm going to add, after the words licensed professional counselors or as an eligible clinical supervisor, I'm going to add the words for clinical supervision via telehealth. Again, so this rule in general is only for those being supervised by telehealth. And I just wanted that to be clear in the intent, because non-telehealth supervision is governed by a whole other statute. So that would be page 1, line 5.
Senator Masi, on the amendment, is there anyone who wishes to speak on the amendment? If there's no one who wishes to speak on the amendment, Speaker, you may close on the amendment.
I'll waive closing.
Closing has been waived. On the amendment, is there any objection? Seeing, hearing none, amendment passes. Speaker Terlahi, you have the floor.
Senator Masi, on page 2, again, to the intent of the bill on lines 1 through 5, I'd just like to add the words by obtaining clinical supervision via telehealth. So it just explains that this provision only applies to those obtaining clinical supervision via telehealth. Lines 1 through 5 on page 2 of the bill. And I'm also adding on the section that's cited in the bill, section 10407, I'm adding subsections D1. On the same amendment. This is just to the intent.
On the amendment, is there anyone who wishes to speak on the amendment? If no one wishes to speak on the amendment, Speaker Terlahi, you may close. Closing is waived. On the amendment, is there any objection? Seeing, hearing none, amendment passes. Speaker Terlahi, you have the floor.
This is just Masi, colleagues. On page 2, again, lines 6 through 9, still on the intent of the bill. I'm just adding the words via telehealth to that last paragraph that's in the intent right now, to make it crystal clear.
On the crystal clear amendment, is there anyone who wishes to speak on the amendment? If no one wishes to speak, Speaker Terlahi, you may close. Closing is waived. On the amendment, is there any objection? Seeing, hearing none, amendment passes. Speaker Terlahi, you may continue.
Mrs. Masi, again, so now on the section 2 of the bill, which is the actual meat of the bill. The bill already adds licensed professional counselor to the list of people that can supervise. I also want to, by this floor amendment, add licensed clinical social worker, which is also in the statute and missing from this one rule, so that this rule will again be exactly the same as the statute. And this should be, on this amendment, it should be a semicolon at the end, and the rest of the bill should be there. So if the clerks could take note of that. This paragraph that I've printed should be semicolon at the end, not a period. Of course, it adds the word, changes the word of with the word with.
Mrs. Masi, Madam Speaker, on the amendment, is there anyone who wishes to speak on the amendment? No one wishes to speak on the amendment. Speaker Terlahi, you may close. Closing is waived. On the amendment, is there any objection? Seeing, hearing no objection, amendment passes. Speaker Terlahi, please continue.
This is a final amendment. This is a paragraph I'd like to add to the bill, and I'm going to move to add this to after line 9. So a new paragraph in the intent of the bill on page 2. So this whole paragraph, this again just shows that this bill is for telehealth supervision, but I'm citing the other statutes for regular supervision so that everybody can see it easily. The paragraph will read, "Y Legislature in Guam finds that the requirements for clinical supervision are as stated in rules and regulations, section 2, 10407D1. The requirements for in-person, face-to-face clinical supervision remain consistent with those listed in 10 GCA Health and Safety, Chapter 12, Sections 12301, 302, 303 regarding licensure for LPCs, licensed mental health counselors, and family marriage therapists, as well as those specified in Rules and Regulations 103063 regarding licensure for licensed psychology associates." I think there's a typo in here, stated in rules and regulations up there, that second line should take out the word section 2. It should be just 10407D1.
Let's take a short recess. I think there's some members who didn't get the amendment. Speaker Terlahi, you have the floor.
All right, so I read the amendment, the last amendment. It's to add a new paragraph to the intent on page 2. And in the version that's passed out on the second line, I think it's a typo, and we should remove the word section 2, and it should just read Rules and Regulations, section 10407D1. this again is just a description of the authority that we're talking about. So for telehealth, it's in 10407D1. For regular supervision, it's in these other sections of the 10 GCA. Yes, and I'd like to ask that legal be allowed to make technical corrections. That's noted on the bottom here as well.
Sidos Masi, Madam Speaker. On the amendment, is there anyone who wishes to speak on the amendment? If there is no one who wishes to speak on the amendment, Speaker Terlahi, you may close.
I'll waive closing on this amendment.
Closing is waived on the amendment. Is there any objection? Seeing, hearing none, amendment passes. Speaker Terlahi, you have the floor.
All right. That's it on this bill. For now, I'll allow my other colleagues to speak. Sidos Masi.
Sidos Masi, Madam Speaker. On the main motion, is there anyone who wishes to speak on the bill? On the main motion? If no one wishes to speak, Speaker, you may close on the main motion. Thank you.
Thank you. I was hoping this would be a simple bill. I had to learn a lot in order to do it, though, even though it looks so simple, because the Allied Health Board is so large. It takes care of all kinds of fields, including these for the counselors and who can supervise these licensed professional counselors, even some of which, such as the social workers and the psychiatrists, who are actually governed by other boards. So it's very interesting, but I just want to thank the Allied Health Board for the work that they are doing to promptly review and deliberate and meet. They meet regularly, and so that they can take care of those who have applied for license. And hopefully this will assist them and remove any impediment to future licensing or swift licensing of these individuals that Guam greatly needs. So, and I ask my colleagues for their consideration to pass this bill as amended. And I'd like to move the bill as amended by the committee and as amended, further amended on the floor to the third reading for voting.
On the motion to move the bill to the third reading file, is there any objection? Seeing, hearing none, motion carries.
Sidos Masi. We're now on bill number 358-37 COR. Senator Barnett, you're the primary sponsor. You're recognized.
Sidos Masi, Madam Speaker. I'd like to move to place bill number 358-37 COR into the third reading file, and I'd like to discuss.
Please proceed.
Sidos Masi, Madam Speaker, and good afternoon, people of Guam, and to my colleagues as well. Bill number 358-37 COR is an act to add a new subsection 90.16.3 to Article 1, Chapter 90, Title 9, GCA relative to salary recruitment and retention studies for law enforcement officers employed by the Guam Department of Corrections. A very simple bill. It requires the Department of Administration conduct a salary recruitment and retention study for hardworking corrections officers every 3 years. The bill originated as a floor amendment proposed by myself during the fiscal year 2025 budget session. However, it was ruled out of order because it was submitted late. The Competitive Wage Act currently requires salary studies for all employees of the government of Guam every 3 years. This bill, however, adds recruitment and retention studies to the requirement. In April of this year, as my colleagues are well aware, DOA implemented the results of a study to add retention pay to the Guam Police Department officers' salaries, and that retention pay was 25%. Therefore, DOA can use the same mechanism to perform a study for corrections officers as well, and I know that they're hoping for the 25%, but we'll see now what the results of the study are. And so this kind of started under the leadership of the former director, Joseph Carbolito, who I think had discussed this possibility of a retention pay as one of his ideas to address the shortage of corrections officers in the Department of Corrections. And at the time that he discussed this with some of the officers, I don't know how far it got, but basically the officers got wind of it and they were under the impression that it was something that was going to happen. And then we saw the movement of the former director, Carbolito, over to the Guam Police Department, and for all intents and purposes, forward motion on whatever that discussion was, basically halted, and then we saw the Guam Police Department receive the 25% retention pay. And so I basically approached DOA Director Ed Byrne in one of our committee of the wholes, and I said, hey, how do we get that similar study done that we conducted for Guam Police Department officers done for Department of Corrections law enforcement personnel? And he said, basically, pass a bill. And in the bill, require him to conduct the study, and that's what this bill is, and that's why we're here today. So any retention incentives, adjustments, or differentials will require an obvious appropriation for each year, depending, again, on the results of this study. As we all know, the Department of Corrections is very short-staffed, and I'm pretty sure we can argue about, whether they have too many inmates and detainees, too few guards. I think it's both, actually. But we're looking now at ratios, as the director has said on the record in the room across the hall during public hearings, anywhere from 80 inmates and detainees to a single officer. So again, anything we can do to attract the recruitment of new officers and also have the ability to retain officers who currently work in the Department of Corrections, I think goes a long way towards addressing some of the chronic staffing shortages that we've seen at the Department of Corrections. Because remember, this although the ratio of 80-1 might be significantly higher than ratios we've heard in the past. I remember when I first joined the media, the ratio even back then was very unsafe for the corrections officers and the law enforcement personnel who work inside the Mangilau compound. So again, I ask the support of my colleagues in passing this bill so that DOA again can conduct the study, which I'm very hopeful will reveal that the Department of Corrections law enforcement personnel are entitled to an increase in recruitment and retention in their pay for the purpose of recruitment and retention. Sidus Masi, Madam Speaker.
Sidus Masi. On the bill, is there any other senator? On the bill, Senator Blas, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I'd like to be able to support, but just one question, if the author can yield to this thing with regard to the cost for the study, how is that going to be taken care of?
Would the sponsor yield?
I would just say that in my discussion with Mr. Byrne, he didn't indicate that we would have to pay for the study, that it would be conducted under the existing budget that we appropriated for the Department of Administration.
Okay, thank you very much, Mr.
On the bill, is there anyone else who'd like to be recognized on the bill? on the bill? If not, then sponsor may close on the bill.
Just want to thank my colleagues for their consideration and hopefully for their support of this bill, as I would like to see it pass. So again, I think that this study is long overdue, so the quicker we can get it passed, I know that they're very willing to engage in the work at the Department of Administration. Si Diyos masi, Madam Speaker. And I would like to motion to place the bill in the third reading file.
The motion to place the bill to the third reading file. Is there any objection? Seeing no objection, Bill 358-37 COR is placed to the third reading. We're now on Bill 363. We're going to take a 1-minute recess.
We're on bill number 363-37 COR. Speaker Terlahi, you are recognized.
Suzus Masi, I'd like to suggest that we do not have a quorum, and I'd like to ask that we do a roll call to determine that on the record. We have bills that need to be passed. They're at the request under timelines requested by the administration. So I would ask that at the very minimum, a roll call be held.
Yeah. All right. Would the clerk please conduct our roll call of members? Sidos Masi.
Senator Barnett. Senator Blas. Senator Brown. Senator Duenas. Senator Fisher. Senator Lujan. Vice Speaker Munya Barnes. Senator Parkinson. Senator Perez. Senator Kanata. Senator San Augustine. Senator San Nicolas. Senator Shelton. Senator Taidui. Speaker Terlahi. Mr. Speaker, we do not have a quorum.
Sidos Masi, Madam Clerk. Speaker.
Thank you. I've not been told the reasons or the return times for any of these senators, except for the ones that have sent in their official off-island notices and the ones that have informed us that they are either sick or their family members are sick, which are a couple of senators. But the rest, I have no reason it's been told to me. So but we still have business to do. There are still bills on our agendas we need to pass. There are still nominations we need to vote on. So I would move that we recess until 9 a.m. tomorrow, and that if we don't get a quorum at 9 a.m., that we call the House and ask our Sergeant of Arms to be prepared for that. Sidos Masi.
Sidos Masi, Madam Speaker, yes, you have been very persistent in your pleading with the members to be present so we can maintain a quorum and conduct people's business. So that being said, we will recess till tomorrow morning at 9. Ask members to be prompt and, more importantly, to be present. Sidos Masi.